Greetings, everybody. Katie Taylor here with the AMBA. We're going to get started very shortly. I'm just going to go through a few housekeeping things first before we get started. And I pulled up the wrong thing here. Let's see. Let me make sure that y'all are seeing what you're supposed to be. You are? Okay. So today's webinar, welcome. We're going to cover reading the tea leaves. What are the top risks your practice and or third-party billing company will face in 2025? The next Lau Parker webinar in this series is Compliance Pitfalls with Physician Practice EHR Systems, Deficiencies You Must Address Now. And that's going to be on Tuesday, February 11th. And it's going to start at the same time, 11 a.m. Central. And if you want to sign up for more webinars in this series, you can go to this website. If you want to learn more about the Lau Parker team, please visit www.lausparker.com. So for today's presentation, there's going to be about 50 minutes of content and 10 minutes of Q&A at the end. An email will be sent out an hour after the webinar ends, and it will go to the email address that you used when you registered through GoToWebinar. It'll include the links for today's presentation as well as the CEU certificates for AMBA, AAPC, and PMI. You must be logged into the webinar online and be viewing the slides to get CEU credit. So what that means is the system is just simply not smart enough to track attendance through traditional copper phone lines. It has to be through your individualized link that you've been sent after you register. And if the email doesn't go out straight at 12 p.m. Central on the dot, don't fret, because if we don't end until 12:10 Central, that email will not go out until 1:10 Central. Again, this webinar is pre-approved for 1 CEU. How to participate in today's webinar, we recognize that there are multiple different views and looks that you could have to the webinar. So if you've joined from your browser, it probably looks something like this. Your mic will be disabled. If you can get to the questions tab, you can ask a question. If you can't get there, you can raise your hand and I will reach out and a question area will pop up. If you want to download your handouts, click on the little piece of paper and it should come up. If you don't see that little toolbar on the right-hand side of your screen, maybe you're on a tablet or something with a touch screen, tap on your screen and it should come up, or click on your screen if you're on your desktop. If you're joined from the software, it will look something like this. Again, your mic is disabled. You have the feature where you can raise your hand, ask questions, download your handouts. There's also this handy dandy little sound check area. If you're having trouble with your sound, click on it. It's pretty straightforward. So just a couple of announcements not related to today. We are doing an informational session on Thursday with HCP HIPAA Compliance Pros, and we are rolling out a new accreditation program for organizations and companies in conjunction with them. So it's accredited by AMBA, powered by HCP. And if you want to learn more about that and how it can put you ahead of your competition and help you land more contracts with providers, go ahead and register for that. We do have a coding course bundle that's available, and it's 30 AMBA CEUs that are awarded with that. It does have information on the new telehealth, E&M, and remote therapeutic monitoring codes. The recordings are on sale for $149 from the conference. You can get AAPC and PMI CEUs for that. You just have to take a 40-question quiz. Okay, so let's get to what y'all came for, the webinar today. We are really happy to welcome Robert Saltaformaggio and Matthew Catoe to present to our webinar today. And thank you guys for being here. And Robert, he's been with the firm for a couple years now, I think. And Matt, how long have you been with Lau Parker?
I'm a new associate. I joined in 2024, so I'm coming up on year 1.
And you said that you previously worked for HHS or worked with HHS.
Yes, I used to work with Health and Human Services, both their investigation arm for Medicare, Medicaid fraud enforcement, and then later lateraled over to do a brief stint with OSIG, the Office of Counsel to the Inspector General, largely dealing with exclusionary penalties and the hearings associated with those penalties when they were leveled, usually related to an anti-kickback or False Claims Act statute.
And you're taking over a lot of the caseload and contracts for Richard Pecor, who passed away sadly last month, right?
That's correct. Mr. Pecor unfortunately did pass away due to complications with surgery. I've inherited most of his billing contract work. I will be handling billing contract work and matters for the firm going forward. I did have the privilege of being trained under Mr. Pecor before his untimely passing, and I look forward to maintaining the model of excellence that he's had on all of his work to date.
He's going to be greatly missed. He was an amazing guy, and sorry, I just wanted to touch on that for a moment because I know a lot of people knew him as the third-party contract guru, and so I wanted them to be aware of where to refer their questions to moving forward for that. Robert, if you will you tell us a little bit more about yourself while I'm getting y'all's presentation pulled up?
Yeah, sure. Howdy, everyone. So this is actually my second stint with Lyles Parker. Round two, I've been with the firm now for, I guess, almost 2 or 3 years now. But I've started off working at Lyles Parker right out of law school, doing healthcare, and then in between then and my second stint, I did time as an ethics attorney at the Department of Commerce, and then actually spent some time with Amazon working in compliance related to political engagement and lobbying activities, and then decided I just couldn't get away from being an actual lawyer, so rejoined Lyles Parker back in February, I guess, 2023, and I've just been here and enjoying it and appreciating the opportunity to speak to everyone in these webinars.
We're really happy to have you both, and we thank you for donating your time to presenting this webinar free to our clients and the Lyles Parker clients, and I'll let you guys go ahead and take it from there.
Awesome. Well, thank you, Katie, and it's a pleasure to be here with Matt, my colleague, and hope everyone's 2025 is kicking off in good terms and everyone's staying warm as these polar vortexes seem to be hitting everyone and everywhere. And if there's anyone here online out in California, our hearts go out to those who may be affected by the fires out there, but you're in our thoughts and prayers. So with that said, let's go ahead and kick things off today. Reading the tea leaves, enforcement risk areas that you're likely to see in 2025. Next slide. So as you probably know and have dealt with, there are just a whole slate of different enforcement entities at both the federal level, at the state level, and then even with private payers. And a lot of these, the goal is to identify any waste, fraud, and abuse, whether it's in the federal Medicare or with the joint Medicaid programs. And as you can see, there's just a slew of alphabet entities and contractors, whether they're RACs, UPICs, ZPICs, CERT contractors. You have the MACs at the federal level, the MICs. You have the state level MFUCUs, the Medicaid fraud enforcement units, as well as, with the private payers, they have their own special investigation units. So you are just inundated with all of these various entities whose goal is, to perform audits and to try and identify any waste, fraud, and abuse. Next slide. So Matt and I are going to talk about 10 different risk areas that we see you'll probably likely encounter in 2025. And the first one, I'm going to jump into are these Medicare Advantage and Medicaid managed care concerns. CMS is actively working to move all Medicare beneficiaries to these accountable care plans. We might think, we've all seen that, there's a lot of red tape with government entities, and that we might get faster and better results moving our Medicare beneficiaries to, these health plans that are managed and operated by these private payers. But with, the potential for more efficiency and less red tape, there are some concerns that we've been seeing with these new entities. Next slide. One of which is that your appeal options and appeal rights are going to be vastly different than what you're granted with traditional Medicare or even Medicaid entities. So, for example, with a Medicare beneficiary, if you undergo an audit and receive an adverse determination, your appeal rights, whether that's a request for redetermination up through reconsideration in ALJ to the Medicare Appeals Council, or even up to federal court, your rights and your time, your deadline and the timeline to file an appeal are all spelled out in, Medicare regulations, so that you could go online and see, hey, I have 120 days from the date of a demand letter to file an appeal. Well, what we've been finding out is, you kind of have to get into the weeds with these Medicare Advantage plans. And, in one example dealing with WellMed, we got a response from the general counsel who noted that WellMed is not a payor or healthcare plan, it's a CDO. So what's a CDO? A CDO is a care delivery organization, and it's a legal entity whose primary mission is the delivery of healthcare related products and services. The issue here is that your appeal rights are not going to be spelled out in a regulation that you can easily access online. A lot of times these appeal rights and your deadlines are going to be outlined in your contract that you have with these third party, CDOs or payer plans. And so, it's going to outline how the appeal is going to go, what it's going to be, what rights are going to be governed by. In this case, when we dealt with WellMed, it noted that any appeal would be settled exclusively by binding arbitration in San Antonio, Texas, and all the rules would be pursuant to the HLA dispute resolution. So again, the issue is that any number of different payers are going to have your appeal rights outlined in these contracts. Next slide. So what do you need to do? You need to review your contracts, with a fine-tooth comb, because again, it's going to outline, whether you have an appeal, and if so, is what the rules are going to be governed by, if that's by binding arbitration, or if you might have, one level of appeal to either another entity within the private payer, or if it's going to be reviewed by a third-party group. The deadline to file these appeals are all going to be spelled out. And so you really need to review all of these contracts. And unfortunately, each contract is going to be different. So if your Medicare beneficiary is governed by a CDO under WellMed, WellMed's contract is going to outline different rules than Aetna, which is going to outline different rules than United. So it's just a hassle that you're going to have to jump through, but it's really important that you read your contracts to know your rights. Next slide. Okay, I'm going to quickly turn it over to Matt, who's going to discuss the next couple risk issues.
Sure. So the second risk issue that we expect some friction in the year 2025 are specifically around non-competes in employment contracts and their independent contractor agreements. The Federal Trade Commission issued a final rule in the Federal Register that covers non-compete clauses. Simply put, it's a comprehensive ban. As everyone may well imagine, that did not go over well with entities that want non-competes, and it went over very well with individuals who want out of non-competes for a variety of reasons. In July of 2024, a federal court in the Eastern District of Pennsylvania sided with the FTC, ultimately upholding the rule And later in August of 2024, a federal court in the Northern District of Texas kept the final rule from going into effect. They asserted that the Federal Trade Commission had overstepped their authority in creating the rule and setting up a potential Federal Trade Commission appeal to the Fifth Circuit. The current status of both of these conflicting cases has resulted in a pseudo-nationwide injunction as each matter works its way up to the through the federal appellate system and probably ultimately to the Supreme Court. We don't know if the final decision will come out before the Supreme Court rules on it, but a matter such as a comprehensive ban on non-competes throughout the United States, we would anticipate will likely get in front of the Supreme Court, though we can't say for certain. Obviously, the big follow-up question to that is the incoming Trump administration. We don't have enough information at this time to thoroughly speculate onto whether or not Mr. Trump's second term will affect the non-compete injunction, nor if his Federal Trade Commission will differ from the Biden Federal Trade Commission and how they've approached the litigation. There's simply too many items up in the air right now for us to thoroughly speculate. Next slide, please. For billing companies, this matters to you specifically because, as Salt was mentioning in previous slides, contracts are key here. What language is in the contract? What are you looking to enforce against your employees? And what might be an area of liability or risk that we'd like to minimize going into the year of 2025? We encourage all of our clients and everybody attending this webinar to thoroughly review your employment contracts and your independent contractor agreements. Do you have an effective one in place? And if so, does it contain any non-compete language, any non-disclosure language of trade secrets, customer lists, or proprietary information? Does it cover non-solicitation or non-recruitment of staff? And if so, how are those 4 items differentiated from one another? What do we do if someone breaches the contract? And it helps to just take a fine-tooth comb to these contracts on an annual basis, just to make sure that all the areas of liability are covered and that your organization has enforcement opportunities where they want them and is staying out of the crosshairs of any litigation or enforcement mechanisms that may come out of whatever results from the current FTC litigation. Next slide, please. The third risk area that we see going into 2025 very much involves HIPAA and the Office of Civil Rights. We've noticed a very pronounced uptick in the OCR's enforcement of HIPAA violations, both alleged and real. It is likely in relation to the Change Healthcare breach of 2024, currently the largest U.S. healthcare breach of private and proprietary information by a third-party entity. Litigation related to that breach is ongoing. We're not going to get into the details of that breach during this presentation, but it is likely the biggest tangent for why OCR has begun their latest uptick. Since the compliance date of the privacy rule in April of 2003, the OCR has received 369,000 HIPAA complaints. And as of August of 2024, the settled imposed civil monetary penalties have resulted in assessments of $143,728,972. Those are just those settled from the implication, excuse me, I forgot the word for a second, the implication of the privacy rule up to 2024. It is also worth noting that OCR can make referrals to DOJ for a criminal investigation where appropriate, involving knowing disclosure or obtaining of protected health information in violation of those rules, which means that organizations can face a civil investigation from the OCR, the Office of Civil Rights, and a corollary criminal investigation from the DOJ on the same facts at the same time. To date, the OCR has made a little under 2,500 such referrals to the DOJ. The general areas of compliance largely center around impermissible uses and disclosures of protected health information, a lack of safeguards to that protected health information, and then on the other side of the coin, a lack of patient access to their protected health information. The short version of this third bullet can be summarized as, if the patient has proven they are who they say they are, or it's another individual on an authorized disclosure list, and they have otherwise proven that this is their PHI and they're allowed to have access to it, timely disclosure is paramount so as to not provoke an OCR investigation. And finally, use or disclosure of more than the minimum necessary. Do not give out full bulk files unless you have to on patient request or other legal compulsion. Simply, we don't want OCR to come sniffing around where they don't have reason to. Next slide, please. So going back to the third bullet that I mentioned in the last slide, the right to access patient records has become an uptick in HIPAA enforcement. In November of 2024, the Office of Civil Rights announced a civil monetary penalty of $100,000 against a mental health provider based on a complaint that the provider had failed to provide timely access to the patient's medical records. The HIPAA privacy rule requires that individuals or their personal representatives have timely access to their health information, which has been codified as within 30 days. So within 30 days from the patient or their authorized representative proving they are who they say they are, you have to turn over their records, absent some legitimate legal reason as to why those medical records should not be disclosed. And that reason should be in writing. This was the 51st right to access case brought by OCR, and we do fully expect an uptick in these matters as we move forward, simply because patients, when they request their medical records, want them in what could be conceived as an annoyingly quick turnaround, but they are owed those records. They are entitled to them by law, and as the keeper of the records, it is your organization's responsibility to get those records out in a timely fashion. The other side of the coin for HIPAA is what it's always been, a lack of safeguards for protected health information. The Office of Civil Rights initiated an investigation of a Washington state hospital following the receipt of a breach notification report stating that 23 security guards in the hospital's ER system used their credentials to access EMR with no specific job-related purpose. To resolve these allegations, the hospital agreed to a just under $250,000 settlement and implementation of a plan to update its policies and procedures to protect safeguards further. A separate, higher administrative cost that the hospital had to front, but the exact numbers were kept behind closed doors. Next slide, please. So I'm going to go ahead and pass back to Salt here for the False Claims Act liability for billing companies and providers. Salt, would you like to take it away?
Yeah, thanks, Matt. So we're seeing enforcement actions from the government involving fraud and false claims really start to ramp up post-COVID. In FY 2023, we saw those judgments exceed $2.68 billion, and of that, more than $1.8 billion was attributable to healthcare-related cases and matters. I know we're already well into FY 2025, so we expect the FY 2024 stats probably to come out within the next month. So we'll be able to update this information, but we assume that it'll continue to show an uptick. And during FY 2023, we saw more than 700 whistleblower cases were filed. A record 1,212 new False Claims Act cases were initiated. And that was the first time more than 1,000 new False Claims Act cases had been filed in just a single year. And notably, during that year, the DOJ and whistleblowers were party to more than 500 settlements and judgments, the highest number in a single year. Next slide. So we often like to use some case examples just to show you what some of the providers out there are getting in trouble with related to False Claims Act liability. In our first case in Maryland, we had a medical billing company for diagnostic labs had agreed to pay more than $300,000 to resolve FCA allegations. Notably, the government alleged that the lab directed the billing company to bill Medicare for respiratory pathogen panels purportedly ordered by a physician who had not ordered the test and who was ineligible to treat Medicare beneficiaries. The billing company then found the credentials of a different physician and of a different physician, and without that person's authorization had billed Medicare using his name. Down in California, or I should say out in California, a billing company and others agreed to pay nearly $24 million to resolve FCA allegations. In the complaint, the government alleged that the defendants, which included a medical billing company, had falsified the place of service for skin grafts and billed multiple times for single-use skin substitute products. The government had contended that defendants manipulated a place of service code on claims for skin grafts to fraudulently maximize reimbursement from both Medicare and Medicaid. Just speaking just quickly on skin grafts, we're seeing that's definitely one area among providers who have, we've just seen a significant uptick in audits and other, administrative actions. So that's one area that's really going to be big for 2025. Next slide. So, okay, I think I accidentally included the same slide a couple times. So, if you move forward. There we go. So in New Jersey, we had a medical billing company and others who were again sued by a relator who, for those that's just a legal term for a whistleblower under both the federal and multiple state False Claim Act provisions. That relator had alleged that defendants regularly changed, added, or removed billing codes, modifiers, diagnostic codes, procedures, revenue codes, accident indicators, or units of time and length for patient stay, all of which were done without the input or approval from the treating physician or the facility. Notably, the defendants were alleged to have engaged in assumptive coding, which the OIG described as coding of a diagnosis or procedure without any supporting clinical documentation. The government alleged that the defendants were motivated and incentivized to engage in the fraudulent conduct due to the contractual percentage fee arrangements maintained with their clients. Next slide. So not only can there be, liability under the FCA, but there's also potential criminal liability for, certain actions, especially involving billing companies. Again, we love using these examples just to give you an insight into what's going on. So in Michigan, a medical biller was sentenced to 50 months in prison. The government alleged that the biller knowingly submitted fraudulent bills on behalf of a co-conspirator physician for services she knew could not have been rendered, and for services she knew had not been rendered as billed. In exchange, the biller was paid 6% of the monies paid to the physician from Medicare. In Florida, we had a medical biller who was sentenced to more than 5 years in jail for healthcare fraud, aggravated identity theft, and filing a false tax return. The government alleged that the biller abused his role by wrongfully accessing and utilizing the company's patient information and a client physician's name and identification number to submit false and fraudulent claims to Florida Medicaid for services that were not rendered by the client physician. The defendant was also alleged to have altered the pay to information associated with the HMO's payment processor so that the payments for the non-rendered medical services were sent to bank accounts under his control. Next slide. Just a couple more examples. In Illinois, the government alleged that a biller knowingly submitted, that was kind of like one we just did. I'm sorry. We'll go to the Alabama. Here we had another biller who had a role in a scheme that included submitting claims using Medicaid identifications of friends and family members' children for counseling services that never took place. The clinic owner, who was a psychologist, paid the biller a 10% commission for all claims paid by Medicaid. Next slide. Okay, just last two examples. In Nevada, we had the State Attorney General's office prosecuted a biller based on allegations that he submitted claims for rehabilitative mental health services allegedly provided by one of its providers during times when the provider was traveling out of the country and could not have provided the services to Medicaid recipients in Nevada. And then finally, in California, we have a dentist and others who recruited Medicare beneficiaries to get dental work done. They engaged in fraud, and to conceal it, the office's former billing manager and office manager submitted false documents to Meridian, one of the auditors for Medicare. And the billing manager pleaded guilty and faced 5 years in prison and fines up to $250,000. So, what do these examples show? The biggest issues is, submitting claims for services that were either not rendered or, submitting claims for services that were improperly rendered and then trying to cover it up. So that's something that as billers, you really need to go through and make sure that, all of the claims that you're submitting, whether it's to the federal Medicare program, the joint state, federal Medicaid, or even to private payers, that, you're reviewing all the documentation to make sure that what's there in the claim forms and on the documentation, accurately captures the services that were rendered. Next slide. Risk issue number 6, one of my favorite incident to billing concerns. We see that there's just always tons of issues dealing with incident 2, and mainly because, while it's permissible at the federal level, there's so many different state laws that affect, whether it is permissible at the state level, including all of the requirements, and even we've seen that not all private payers recognize incident 2 practices. So the problem here is that, with the various payers, whether public or private, you may engage with as part of your practice, they're all going to have different laws defining whether it's permissible to, to bill for incident 2 and if not. So, improper billing, like even we've seen with the examples we had with the False Claims Act or the criminal cases, any improper billing can lead to either administrative or criminal liability. Next slide. So what can we, try and look to make sure that we're staying in compliance with any of the incident 2 billing requirements? Well, first, state licensure is required. So you need to make sure that both the supervising physician and the mid-level practitioner whose services are being billed are properly licensed by the state in which they're practicing. Notably, at the state level, the scope of practice, there's going to be a wide array of limitations of what's permissible to be billed for incident 2 from one state to the next. So you need to make sure that you're reviewing the laws of the state in which you're engaged to determine whether the services that are being rendered by that mid-level practitioner falls within his or her scope of practice that's permissible. Most states require that mid-level practitioners like NPs work under an appropriate collaborative practice agreement. And notably, I'll just highlight, you need to make sure that practice agreement is written. Medicare Part B covers services that they perform only if the services would be covered if furnished by the physician, is not otherwise excluded statutorily from coverage, and the mid-level practitioner performs the services while working in quote-unquote collaboration with a physician. Notably, like we highlight there at the end, the physician with whom the mid-level practitioner is collaborating does not have to be the practitioner's supervising physician for incident 2 billing purposes. Next slide. So some more practical considerations. Notably, there needs to be an employment relationship between the credentialed physician and the qualified mid-level practitioner who is providing the incident 2 services. So whether that's, they're both employed by a group entity who are billing for the service, or if the physician is a sole practitioner, that physician must employ the mid-level practitioner. Also, the services rendered by the mid-level practitioner must be an expense to the employer. So that cost must represent a direct financial expense to the practice, regardless of whether the individual is a W-2 employee, a leased employee, or a 1099 contractor. Next slide. The role of credentialing is very important. So again, you need to make sure that the supervising physician is licensed and properly credentialed with Medicare if they're doing it, Medicare, or is credentialed with the appropriate state healthcare entity or with the private payer, and that the services performed by those mid-level practitioners, may be billed under the physician's MPI. You need to make sure the services occur in a non-institutional setting. So that's going to be any setting other than a hospital or skilled nursing facility. And then, finally, the services that are rendered must be an integral, although incidental, part of the physician's professional service. So again, according to the Medicare Benefit Policy Manual, there must be subsequent services by the physician of a frequency that reflects the physician's continuing active participation in management of the course of treatment. And one thing to flag is that you cannot bill incident 2 for the first service that is provided to the patient. The credentialed physician must have already established a relationship with that patient so that the mid-level practitioner then can provide the subsequent services. So again, if the patient comes in, it's their first time, you can't bill for the incident 2 if it's that first encounter. Next slide. Just a couple more risk issues related to incident 2 billing. If a service would normally be billed out of a physician's office, it's likely one that would qualify for incident 2 billing. You need to make sure the services, again, are commonly furnished, where supplies are clearly of a type a physician is not expected to have on hand in his or her office, or where the services of a type are not considered medically appropriate to provide in the office setting. It's likely that these services are not going to be covered under the incident 2 provision. And then finally, one of the biggest issues I've seen with incident 2 is this direct personal supervision requirement. For incident 2, to bill under that, the physician must be an active participant in and manage the patient's course of treatment. So under the regulations, what defines this direct supervision means that the physician must be present in the office suite and immediately available to furnish assistance and direction throughout the performance of the procedure. And as the regulation notes, that doesn't mean the physician, has to be present in the room, but he or she has to be somewhat accessible. So, down the hall would be fine, but if you're on the first floor and the setting you're in has 10 stories, and the physician's up there on floor 10, Medicare or any other payer is likely not going to find that there was direct supervision going on. And oftentimes, the payers we've seen have also liked some sort of documentation in the record indicating that the physician was providing direct supervision in order for the claim to be paid under incident 2. Next slide. All right, I'm going to turn it over. I'm going to take this last one with the false diagnosis codes. Very similar to some of the examples we used earlier, some of the issues we're seeing is that, a lot of billers and providers are submitting claims with false diagnosis codes. Using some examples here, in California, there was a hearing aid company that agreed to pay nearly $35 million in which it had submitted claims with unsupported diagnosis codes. The government had alleged that the defendants included these unsupported hearing loss related codes on super bills, even after internal audits had been completed that resulted in the defendant knowingly submitting or causing the submission of false claims for payment. Similar in Louisiana, there was another allegation where the defendants had falsely submitted diagnosis codes with students for mental health disorders, even though the students did not have these disorders. Next slide. Now I'll turn it over to Matt to finish it up.
Thanks, Salt. So the eighth area that we really want to bring to everyone's attention are the percentage-based compensation issues or percentage-based billing agreements. Salt pointed out in multiple examples in prior slides, when the compensation model becomes percentage-based, it is becoming increasingly a problem for enforcement mechanisms across the country, whether that's your RACs, your SMICs, your anybody or everybody in between. They really are cracking down on percentage-based compensation issues. They view it akin to fee splitting. Some examples of the statutes that have come out related to percentage-based compensation include the New York education law cited on your screen there relating to educational facilities as it relates to the healthcare field. There are crackdowns on percentage-based billing agreements there, and a corollary in Florida. So it should show, this slide should show not only that everyone is cracking down on percentage-based, but it's across party lines. It's not one particular state or political affiliation versus the other. It is a universal approach to percentage-based compensation models. We recommend that everybody review their state Medicaid contracts and state regulations governing medical billing companies at least biannually, as the rules are subject to change, and we want to make sure that everyone maintains compliance throughout their consistent billing arrangements. That's not to say that the rules will change in 2025 going forward, but if they do, the onus to remain compliant, especially in this percentage-based field, does fall to the organization. And that organization, namely the listeners of this webinar, will be in the hot seat in the event an enforcement mechanism comes down the line. And so we recommend getting ahead of that curve and just being aware if the state Medicaid teams propose a rule change, or if there's a new rule coming out of Aetna, TRICARE, Cigna, insert payor here. If they have decreed in any way or given an implication that they don't like percentage-based agreements, it's in your best interest to make sure that you don't have an agreement that is percentage-based in place. Next slide, please. This leads into private payor audit risks. So the private payors are very much looking over EHR audit trails. In most instances, the payor audits will initially ask for copies of medical records, the test results related to those medical records, and so on and so forth. But we are increasingly seeing payors issue a follow-up request asking for the audit trails and patient logs, trying to determine who touched this patient's medical record, when, and what was their legitimate medical purpose. Did they alter any information in those medical records? If so, what? Why? And it's becoming an uptick in the private payor specifically. They're looking for the audit trails. So an audit trail is also known as an audit log. It acts as a record keeper that documents evidence of certain events, like I mentioned, procedures or operations, and their purpose is utilized to reduce fraud, material errors, or unauthorized use in the patient's medical records. It shows on your screen essentially the who, what, when, where, and it is supposed to show, I'm tongue twisting myself, the why. When was a patient records accessed? Who accessed that record? What additional information was added? And was any information changed or deleted are the primary concerns when consulting or accessing an audit trail. This information is important from an enforcement standpoint because it goes hand in hand with general denial rationale, such as lack of medical necessity, lack of signature pages, or other refusal rationale that private payors will use. And if contested on appeal that the procedure or the medical undertaking was in the patient's best interest, was medically necessitated and otherwise rational, the second question they'll follow up for is usually, or at the very least we are seeing an uptick, they're asking for the audit trails and the associated patient logs for those audit trails. So it's important to not only know where those audit logs are in your system, but to be able to lay hands on them in a ready and quick manner so that we can move forward faster through the appeal process in the event they're necessary. Next slide, please. And the 10th risk issue, this is a uptick that we're noticing, a failure to screen for excluded individuals and entities. So the exclusion penalty, known as the medical death penalty in the legal sphere, is a final administrative action that is a legally defined term that bars participation in federal healthcare programs. This includes, but is in no way limited to, Medicare, Medicaid, CHIPS, TRICARE, and FEHBP. Essentially, if it touches the federal piggy bank and you suffer an exclusion, or anybody in your organization suffers an exclusion, you are forbidden outright from billing any of the federal payers. And as we likely don't have to tell you, federal payers, especially Medicare, Medicaid, the big ones, usually account for a wide percentage of a general patient populace payer base. So getting on the exclusion list is, as previously mentioned, the death penalty to most billers and coders. The Secretary of Health and Human Services has delegated this exclusion authority and its enforcement to the Office of the Inspector General. Like we mentioned at the beginning of this webinar, I used to work for both arms of the Office of the Inspector General, both their investigation department and their Office of Counsel to the Inspector General, who oversaw the exclusion authority hearings and the exclusion penalties. Primarily, they say that they're focused on patient safety and the financial integrity of the federally funded healthcare programs. They want to prevent fraud, waste, and abuse at all areas that they possibly can, and the exclusion penalty is one of, if not the penultimate tool with which they ensure there is compliance. It's very, very broad sweeping, it's very, very scary, and it's one of the items you want to see least whenever an enforcement agency is coming down the pipeline. If they mention exclusionary penalty, it's time to lawyer up. In fact, it was time to lawyer up yesterday. There are two separate types of exclusions, the mandatory and the permissive. Mandatory exclusions are identified in the citation on your screen of the Social Security Act. They are imposed as a result of convictions for program fraud, patient abuse, and certain drug offenses. I mentioned in a previous slide that the Office of Civil Rights often can and often does involve the DOJ in what's known as a corollary proceeding. That means while the OCR may be investigating in the civil side of the house, the DOJ may investigate on the criminal side of the house, on the same facts and the same conduct. Mandatory exclusions operate in a similar field. If any individual in the organization has been convicted of a fraud, waste, patient abuse, or certain drug offense that results in a mandatory exclusion, they taint the entire organization for which they are employed. Permissive exclusions are discretionary and can be imposed for a broad range of conduct. Most of them are usually predicated on actions taken by state licensing boards. And most of these actions, approximately 70%, involve nurses and nurses' assistants for that reason. Physicians were involved in 9% of permissive exclusions, and business owners, usually the C-suite, were only involved in about 3%. It's also worth mentioning that all states usually have parallel exclusion authority and considerations for their respective state Medicaid and other state programs. The onus falls to your organization to make sure that nobody, from the intern working the front desk to your highest paid medical director, falls foul of the exclusion list. Because again, if even one person in the organization is on the exclusion list, that spreads to the entire organization and can result in a lot of federal enforcement where there doesn't need to be any. Next slide, please. The OIG's primary concerns about the participation of excluded individuals are specifically related to patient safety and the risk of fraud. Just under half of all exclusions are related to licensing issues, and the main causes of that license issue are substance abuse, fraud, professional misconduct, and patient abuse. So the OIG will cite these statistics when they're upholding their mandatory and permissive exclusionary authorities. They will say that we don't want unlicensed or otherwise previously convicted individuals rendering healthcare to what could be a vulnerable patient. Approximately 50.7% of all exclusions are based on felonies related to the healthcare program itself, specifically to patient abuse, neglect, fraud, or illegal substances. And it really goes hand in hand whenever the question of the exclusion penalty comes up in terms of updating it, altering the statutory underpinnings, or changing the law related to the exclusion penalty. This is one of OIG's first citations, is that most of their exclusions are based on felony predicate convictions. Again, excluded employees present a serious risk to any organization who happens to employ them. Therefore, it falls to your organization to check regularly that all individuals who are actively employed by your organization, regardless of whether or not they are rendering medical care to the patient, are not on an exclusion list. The federal exclusion list is publicly available, as are most state exclusion lists, and it is your organization's role to check, because they are not going to question whether or not it was okay or why this individual was excluded. The first question is, why are you employing an excluded individual? And anything they touch within your organization can be considered tainted for purposes of enforcement mechanisms. So you need to make sure your house is in order before the federal enforcement agencies show up. Next slide, please. So on your screen are some examples of these failures to exclude for individuals. In California, a pediatric home health company paid $377,000 to resolve allegations that it employed an office manager who was excluded from participation in federal healthcare programs. In addition to the $377,000, they also agreed as a company to accept exclusion for 20 years. It is worth pointing out for everyone listening in, the fine is separate from the exclusion penalty. You can get hit with both. In Arizona, a nursing facility paid $86,000 regarding an excluded nursing assistant. South Carolina, a personal care agency paid $115,000 to resolve allegations that it employed an excluded individual providing items or services billed to the federal healthcare programs. And in Minnesota, a group home facility agreed to pay more than $150,000 to resolve allegations that it improperly employed an individual who was otherwise excluded from the federal healthcare programs. Once again, we just want to point out for everyone listening in, if even one employee is excluded, they need to be addressed quickly so as to not implicate the rest of the entire organization. Next slide, please. And that will take us to Q&A. So as a brief reminder, this outline is provided only as general information. It does not constitute legal advice and should not be used as substitute for seeking legal counsel. All rules, regulations, citations, and decisions in these slides are subject to change as necessary throughout their respective litigation proceedings. And Salt and I are both attorneys with the firm of Lyles Parker. If you encounter something that we mentioned in this slide and you would like legal representation, our firm would be happy to assist you. Salt, you have anything else you'd like to add?
No. We appreciate everyone's time today. Katie, do we have any questions for either Matt or myself today?
Yeah, there was actually a couple that I answered, but I think that other people would want to know too. So the one that I just answered was, are ancillary staff listed on the OIG exclusions database? I think they're just asking, is it just providers or who is it on there?
Yes, the short answer is yes. All individuals are, if you get an exclusion penalty, they show up on the list. It's not necessarily limited to just providers. And the general red flag is if name, then check. And that's usually how we would advise someone to review the exclusion list, is if their name pops up. Don't check what they're doing, check if they're on it at all.
And someone asked, let's see here. Does the right to access for patient records still apply if the patient/client refuses to pay fees?
That gets tricky. So we pointed it out in our slide that there can be reasonable costs and fees associated with the obtaining of the patient's right to access their medical records. It has to be reasonable. It can't be the moon and stars for their own records. But if it's a processing fee that your organization charges, I would recommend, and Salt, please feel free to correct me, paper trail, paper trail, paper trail. If you believe you have a legitimate reason to not provide a timely access to a patient's record, immortalize it in email. Say verbatim something to the effect of, we understand you are the patient, you've proven who you say you are, we have your records set aside and are ready to give them to you, but you have to pay this cost associated with obtaining those records. I'm assuming it's an administration fee, but Saul, please feel free to correct me. Just paper trail it.
Yeah, I would agree.
Having them sign something when they first start coming into, they have to sign all of their notices, just with a policy stating they understand what happens if they don't pay, or if they don't want to pay for access to their records, and what will happen in terms of suspending services if they don't pay. Yeah, as long as you're having the policy up front and having them acknowledge that they know your policy, that would help too.
Yes, and it's usually just a have and not need rather than need and not have. The more paper trail you have to back up your stance, the easier it is in the event necessary that lawyers can defend your actions.
Okay, somebody added, what if they'll pay for the records, but they are not able to pay for their services? They would still have to provide the records, yes?
I would assume generally yes, if they're asking for their records to date, but they are not capable of paying for ongoing services. Is that the question?
Yeah, maybe they owe a past bill. I still don't think you can withhold the records.
I would agree. I don't think you can withhold the record. Sorry?
Yeah, you still have to provide the patient's record.
Yes, you still have to provide the patient's record, and it can't be upheld for an outstanding bill for services not rendered. You have to give them their records to that day. And then again, going back to our paper trail, you can put in the email turning over those records. By the way, you still owe us ever how many dollars for the services rendered in these records.
So we got quite a few questions on like percentage-based billing and fee splitting in certain states. If they're not going to consult a lawyer and they're wanting to stay up to date on their regulations for that, what do y'all recommend in terms of starting their research on where to look?
The best places to look for percentage-based billing agreements are primarily going to be in the state's respective Medicare, Medicaid manuals, and keeping up to date with the changes in billing and coding procedures within those manuals are going to be a good place to start for the states. The individual contracts signed with private payers, Aetna, Cigna, Blue Cross Blue Shield, etc., will usually have some language relating to a percentage-based agreement, though likely not very thoroughly fleshed out. It is also worth, I would say, and Salt, please feel free to correct me, in the year 2024, a decision came out known as Loper-Bright that did away with Chevron deference. Boiled to its core, it gives a lot more power to individual judges to decide case law outcomes. I don't know and cannot say for certain, but that opens up an avenue for individual case law to change billing contractor agreements. Salt, does that sound like a fair application of Loper?
Yeah.
Okay.
And can they also look at the corporate practice of medicine laws that might exist in their state too?
Yes, it's a good place to look. The only reason I would say not to put too much stock in the corporate practice of medicine is the corporate practice of medicine doctrine, A, is not universal across the continental United States. yet. They're working on it. And B, it's usually trying to keep for-profit healthcare out of particular states. They don't, in my research, really get into the teeth of a percentage-based agreement the way I personally, as a legal professional, would like them to under most of those doctrines. And that's not to say they don't. It's a good resource, but it shouldn't be one of the first ones you look to, in my opinion.
Yeah, that's great advice. We did have a couple other questions. I think that I might be able to get to some of them afterwards pretty easily. Let me see if there's one or two more here. Sorry, I'm just reading through some of these.
No problem.
A former biller of my provider still has access to their accounts on the Availity platform, and I'm assuming won't give it up. What type of legal ramifications could my provider have with them?
So just to make sure I understand the question, this biller is no longer working with the provider client and they still have access to the original EMR systems?
Yes.
Okay. The first thing I would do generally is to question why. I want to know why they still have that access, whether they won't give it up willingly or not. What is their power for holding on to it outside of, if you're no longer employed with the physician client, I can't think of a legitimate reason why a biller should still have EHR access unless they're finalizing some records. Salt, do you want to expand on that?
That doesn't make any sense to me as well. Again, if the employer, the relationship no longer exists, there really shouldn't be any access to the records unless,
right.
Yeah. So
I would think that the first thing I would do if it were me is reach out to the platform specifically. The provider needs to and supply something regarding their contract or something in writing saying that they're no longer in contract.
On their end.
And then perhaps the software can revoke the access.
Yep, that's what I would do, and I would again go back to paper trail. Find whatever document or email chain severed the original relationship and said, from a physician standpoint, we're done with this biller for whatever reason. Find the paper trail that supports they still have access to date, and go to the platform and say, we need this account terminated, turned off, whatever. Is how I'd go about that.
We get this question a lot, and we've answered it a lot over the years, but we'll go ahead and pose it again here just because it's so very important. But this person is wondering, what is their liability as a biller if they have a client that they haven't yet broke ties with and the provider is using the incorrect codes? The provider refuses to change the code despite the biller telling them that there's lack of documentation or medical necessity to use those codes.
That's a big one.
Well, like we've seen in the examples, the biller can be on the hook for just as much liability as the provider, because as the federal anti-kickback statute, False Claims Act, it's not just causes to be, it's not just submits a claims or causes to be, submitting a claim. So if you as the biller are, hitting submit on those claims to the respective payor, you are going to be held in, just as much liability as the provider. So if, from my perspective, if the provider is unwilling to, reassess and render, the proper code or, make that understanding based on your analysis, to me, you need to sever that relationship, because you don't want to put yourself as the biller in any sort of civil or criminal liability.
Yeah, I would second that the False Claims Act says submits or causes to be submitted. So even in the case of if you have a paper trail to back up, you've advised this physician to change or alter their coding. If they're refusing to do so and you press submit, that's an avenue for liability. And I'd very much recommend reevaluating that relationship if you want to continue down that path.
Yeah, like they were saying earlier with other stuff, document that you've reached out to them and told them that this is incorrect and that you're not good with this, and then you have to break ties with that person if they're unwilling to change. But I feel like it varies by each individual biller at what point you would feel obligated to turn them in for filing false claims. I think that just depends on the person, and if it's enough money involved, then you get into like a key TAM scenario.
Word of advice, don't get involved in the key TAM scenario. They're not fun. They're very much not fun.
I bet. I can only imagine. But I think that's all the time we have for questions today. Guys, I really appreciate you staying on late and answering some questions here. I know my announcements push us a couple minutes back at this point. And everyone, we really appreciate you taking your lunch hour to come to this webinar and to, support our association and be in support of Wells Parker. And yeah, if you guys don't have anything else.
I don't have anything.
Nope. Yeah, we appreciate it, Katie, and thank you everyone for attending.
Yes, and everyone, if you have questions related to your CEU or non-content, please don't reach out to these guys. They're very busy. They have a lot of cases on their plate, so reach out to me, Brianna, or Aubrey for those kind of questions. And we're going to let everybody go. I hope everybody has a great rest of your day, a great rest of your week. Please join us on Thursday for the HCP informational webinar, and next week on Tuesday for the denial management webinar. Thanks so much, everybody.